Good afternoon, ladies and gentlemen. Thank you for being here today for joining us on today's webinar topic. My name is Min. I'm from the Young Quantity Surveyor Committee of Singapore Institute of Surveyors and Valuers, SISV. Today's topic for the seminar is on the role of QS and expert witness in arbitration. As the topic suggests, we will look into how QS can assist in arbitration and the expectation, and who are the expert witnesses involved in the dispute, how many types of expert witness are there, what are the expectations of an arbitrator in terms of a decision making. So, and how we also look into how the lawyers and expert witnesses make quantum issues easy for decision making. In fact, this is another aspect of the QS, whereby QS is not all about quantity takeoff and budgeting. One could evolve into expert witness or even an arbitrator. In this ongoing webinar will not be possible without the keen collaboration with Singapore International Arbitration Center, SIAC. I want to thank SIAC for your partnership in making this session possible. Especially, a special thanks to the working team whom I have been engaging with over the past few months. We have come a long way. So today we are very honored to have very profile speakers who are the practitioners from the industry for this topic. The panelists consist of moderator and 4 speakers. May I now invite Ms. Lee from Eldon Law, our moderator, to comment the event. Ms. Lee, please.
Thank you, Imin, for that lovely opening address. Hello, everyone. A very warm welcome to today's panel discussion. This webinar is the first in what we hope will be a series of collaborations between the SISV and the SIAC. I'm Lui Ming, and I'll be your moderator for today. I'm a partner at Eldon Law, a firm with specialist emphasis in construction disputes. I'm extremely pleased to be joined today by a very interesting and diverse panel of leading construction industry experts and very experienced lawyers. Let me now introduce the panelists in the order in which they're speaking today. First, we have Mr. C. Chulip. Chulip? Yes. Chulip has over 30 years of experience as a QS in the construction industry, and he has seen disputes from both sides of the fence. He has acted as the adjudicator in quite a number of adjudications, and he has also acted as an expert witness as well. Next, we will hear from Mr. Kirindip Singh. Kirin is a senior partner. Hi. Kirin is a senior partner at Dentons Roddick, and he has been immersed in the field of construction law for over 20 years. He is an immediate past chair of the IPBA International Construction Projects Committee, and he's also an accredited adjudicator with the Singapore Mediation Center. Third, we will have the pleasure of hearing from Mr. David Bateson. Hi, David. David is a well sought after leading international arbitrator with over 40 years of experience. He has been in Asia since 1980, and he now resides in Singapore. Finally, last but not least, we will be hearing from Mr. Vincent Leong. Vincent is an up-and-coming QS who has seen how things are run at a number of different firms, and he is now at BK Burns. He has experience in tender documentation, contract administration, and claims prep for disputes. Now, we love the audience to be as involved as possible, but as a matter of housekeeping, I should just remind you that there should be a Q&A button on your Zoom screens so you can type in your questions. And I will try to put your questions to the panelists either during the course of the session or at the end of the session if we have time. If we have an overwhelming number of questions, please forgive us if we can't answer every single question. Okay, so our goal today is to share some insights on the role of the QS at arbitration and how best to perform that role of the expert QS. We hope to be able to share some insights and some perspectives into quantum disputes and how to win them. With that, may I lead into our first speaker, Chulip. Chulip, I'm sure our audience is very excited to hear from you. Could you tell us, maybe from your perspective as both a QS as well as an adjudicator, What do you see as the role of the QS in the construction dispute?
A QS can play many parts in the construction dispute. Through my experience, I have played the role of arbitrators, adjudicator, mediator, and even expert determination as a central role. Or I have also played in court and arbitration appointed independent expert, as well as expert for either side or joint expert in that sense. So there are many areas that you can be participating in holding this various positions. Firstly, it comes from construction dispute with the basis of tender, the construction cost. Mainly it's about cost. In construction cost, the dispute mainly between the main contractor and subcontractor, because there are always a lot of gray areas between them. So a QS will come in and look at the tender, look at the construction, the makeup of the construction or contract sum, how they make it out, and determine from, look into that and see where are the areas of where the costs are spread out. Next, QS also involved in the method of measurement. Although there are standard method of measurement in the industry, the SMN2 or even the CP97, but a lot of one contractor and subcontractors work are not so clear, and they are not in that published document. Take for example, you have earthwork contract. They may not be measured in meter cube. They don't deliver in meter cube. They deliver in a truck of 8 meter cube or 8 meter cube of earth or 9 meter cube of earth. If it's not specifically or clearly spelled out in the contract, they will run into this problem. And whether the bulking factor, once you put the earth on or scoop the earth out, is loose, and when it's loose, it becomes more in volume, higher volumes. So you run into that dispute very often. There are many traits between the main contractor and subcontractor. They are not so clearly spelled out. What is included and what is not included in the measurement. So that also have an effect on it. And using the different method of measurement comes into play as well. The other part of it is the valuation of work done, especially in termination of contract. When the contract has been terminated, work done to where? A QS normally been appointed to value what's work been done up to which point. The two parties normally will have different opinion in that. So a QS, either as a joint expert or expert for one party, they have to present it, his way of method of measurement and how you value what work has been done to whichever point of the termination, as well as the material on site, what amount of material on site at the point of termination, and also the defects that's been not rectified at the point of termination. The other area that very contentious are the variations. They tend to call it a VO. The variations is the other area of contention that always come to argument. In the area of variations, there are so many disputes within them. The addition or omission, whether those addition or omission is included in the contract or not included in the contract. You have to look into the drawing, you have to look into the calculations as well. Then the method of measuring the variation come to play as well. And the rates, that is the biggest contention, is the rates. Whether it's in the schedule of rates or not, or what is the market rate, how do you determine the market rates? And finally, the omission, the total omission. When the client or the architect totally omit an item, do you totally omit from the schedule of prices, or do you have to build it backwards using the quantity and the schedule of rates or the market rates to build it? So there's always an argument over that. The other area that QS normally get to involve is also the assessment of loss and expense in the dispute, in terms of extension of time or many other factors that may cause loss and expense. And that area we will not look into the entitlement. Normally the lawyers will go into the entitlements. We will look into the value of it. Okay, how do you determine that? The difficult parts about head office expenses and loss of profit, that's the area that becomes very contentious. As well, the other area that we look into the cause of defects rectification. A lot of dispute comes in the cause of the defect rectification. A lot of time is that building is already about 3-4 years old or 5-6 years old, almost reaching 6 years old. A building surveyor will come up with a list of defects, especially for common area in condominium or industrial building. So with that, QS normally engage to value how much it costs to rectify those defects, and it can come up to hundreds or thousands of defects. Okay. Finally, QS involvement is in the dispute, especially when two parties having QSs as their expert. It goes into reducing the differences. We will come and sit down together and see what are the differences that we can reduce downwards, which are the areas that we can close in turn to reduce to as close as possible in terms of costing, and let the party, either parties, defendants or plaintiffs, to agree on those small amounts and fight on the big amounts. Okay, that's mainly how a QS are involved, very briefly. Okay, I think about that in terms of very brief summary of that, what we are involved in.
Yes. Thank you very much, Tulip. That's a very insightful answer to the question. You know, you wear both hats, and so you're familiar with both sides of the fence. Whilst wearing the hat of a QS as a claims consultant in the course of the project, do you have any practical tips for how people should manage it on this front?
I do very little claim consulting work, but normally a QS who involved in this need to have very strong technical background and the market practice, so that, and very good exposure to the market, so that you know how things are being handled. As my earlier example about the truck taking the amount of quantity of food and so on, you need to know how subcontractor works. If we are QS that sits in the office, you probably will not know a lot of those things. So yeah, so your outside practical experience becomes very important in that area.
Yes. Vincent, what about you? Do you have any views on that?
Yes, I will agree with Mr. Julie over the duties of the QS. In simple terms, QS act as a financial and contract gatekeeper. QS not just only costs and quantities, sometimes you will give opinions on the contractual wording and basis. QS will be assist when the terms of the contracts or the conduct of the parties are unclear. So the QS role here to provide advice of the dispute and find the root cause of the problems, resolve the dispute between the parties. So basically, for example, we have a consultant QS and the main contractor QS. Normally, both sides of the QS, they will sit down during the final account stage, trim through every single dispute and come to an agreement. Then there is a final account statement and signed off by both parties.
Okay, great, thank you. We do have a question, Tulip, from the audience, if you're,
Yep.
Yes. Basically, the question is this. Michael is asking, how is the star rate at best assessed? And what is a fair P&A to be considered for the main con as their entitlement? In some cases, there is an argument that there is no P&A to be paid based on star rates if they are part of the original contract works. And the main con is supposed to carry out the works in the contract. So the reason however, is that it may be in the star rate because the sum is not found in the schedule of rates. So I think the question is really like, how is the star rate best assessed? And what is a fair profit and attendance to be considered for the main con?
Right. Yeah, I agree that that is a common disagreement.
Yes.
Yeah, a star rate, firstly, you have to look at how they determine the star rates.
Mm.
Where do you get the star rates from? Star rates supposed to be fair market rates, right?
Yes.
If it's fair market, how do you determine it from? A lot of time that they will get people or the other contractor to quote for it, which most of the time you don't get an accurate quotation for what you're going to ask for, because the contractor knows that they will not get the job. They know that you're asking for a star rate, rates for a disagreement, for a dispute. They will not give you an accurate rate. So your star rate has to come from first published rate. Where do you get your published rate? There's only one published rate in Singapore, which is BCA's published rate.
Yes.
And the method of collecting the published rate are different. Method of collecting published rate from BCA, they get it from contractor over the period of times, or they get it from consultant, QS consultant, collection of data over that period of time. Every quarterly they collect it during their tender, from their tender. From that will be probably the more accurate rates when you get that in the tendering aspect, competitive pricing. That is probably the more accurate area to look at. But then, when you are doing a variation, the quantity could be very small. With the quantity small, you can't use the tender rate to look at it, because those tender rates are for big quantity.
Yeah.
So you have to adjust that to the actual work you are looking at, and add in all the other small quantities supplements that you have to put it in. Okay, the other area that we will ask is that then how do you add in your profit and overheads, or P&A, profit and attendance? Normally those contractors give you the rate, or you use the tender rate already. They build in the profit and attendance, and your standard form of contract normally says don't allow you to add in profit and attendance, or even in the PSSCOC contract, they will not ask you to add in profit and overheads or profit and attendance, except for those using day work rates, because they are assuming that all the rates that you get from the market would have included profit and attendance.
Ah, I see. Okay. Thank you. Thank you so much for that. I think that leads us quite nicely into the perspective of the lawyer. Can we hear from you, Kirin, on what you see on the dispute resolution side as the duties of an expert witness?
Okay. Thank you, Ming. I have some slides on this, if I could have them flashed on the screen. Yes. So the roles of experts in international commercial arbitration. Of course, the first question, if I could have the next slide, is who is an expert? I mean, this is, I think, something most people know. Someone with a particular expertise in a subject that an arbitrator or the parties may not be familiar with. And an expert, as we also know, can be appointed either by the party or by the tribunal. Now, generally speaking, okay, and we can have a discussion about this later on, but an expert is supposed to be independent, objective, impartial, and credible. So that's the role of an expert. You are supposed to lend your expertise in areas where the parties or the tribunals need assistance, and you're supposed to be independent and objective and impartial. You're not supposed to be on either party's side. But like I said, we can have a discussion about that later. Next slide, please. So types of experts, I've just broken them down into two very broad categories. you have technical experts, and you have legal experts. Now, technical experts you can have in a wide variety of areas: shipping, oil and gas, finance, technology. When it comes to assessment of damages, you have accountants giving evidence on damages, on the calculation of damages. You have delay experts, you have construction experts, you have experts who are who know ground conditions, soil, or maybe civil and structural works. So all kinds of experts in the technical area. Then you also have legal experts, of course, and that's where you need someone to lend his expertise on an issue of foreign law. For example, the arbitration or particular issue in the arbitration may be governed by a foreign law, and the arbitrator may need guidance on that. So that's where you appoint an expert to give his impartial views on what the foreign law is on that particular area. Next slide, please. So as I've said earlier, the expert is there to assist the tribunal on matters within his expertise, and he's supposed to render his professional opinion on the subject matter, and his duty is to the tribunal. So that's what experts always have to bear in mind. When you are appointed, you may be appointed by a party, you are usually appointed by a party. Your duty is ultimately to the court, or in this case, we're discussing arbitration, your duty is to the tribunal. And that's embedded in the rules of arbitration as well as in the IBA rules. IBA stands for the International Bar Association rules on taking evidence. And it says that the expert report must contain a statement of his or her independence from the parties, their legal advisors, and the arbitral tribunal. An example of institutional arbitration rules that also embody that impartiality and independence is the LCIA rules, Rule 21.2. And it says any such expert shall be and remain impartial and independent of the parties, and he or she shall sign a written declaration to such effect, delivered to the tribunal and copied to all parties. Now, this, I think, is the most important area, impartiality. And from my experience, I have seen experts always being questioned, and opposing counsel will refer to the statement of impartiality and many times quote the expert and say, look, you're supposed to be independent. You've signed off, there, look at that paragraph, whatever at the end. You're supposed to be independent, impartial. How can you say that? How can you ignore this fact? Are you really being independent? So very often the expert's independence is attacked. And experts, when giving their evidence, you always have to have that at the back of your mind. Yes, you're appointed by the party, you're being paid by the party. Now, that's a very important factor, right? You're being paid, and money is important. You're being paid. But at the end of the day, your duty is to the tribunal, your duty is to the court. And of course, you have to put the party's case forward, but bearing in mind always that you are independent and impartial. Could I have the next slide? So, of course, experts may disagree very often, and the reasons why experts disagree is quite simple, and I put down 3 reasons. One is factual disputes. One expert may arrive at his opinion based on certain factual assumptions, and while another bases his opinion on a different set of factual assumptions. And why is that? Because of the instructions that they obtain from parties. Parties may give expert different facts, right? You want the expert to believe your side of the case. So sometimes parties do not tell the expert everything. Now, I would advise against that. And from the party's point of view, if you really want the full value out of your expert, and experts as well, if you want to be impartial, ask questions, ask the facts. Don't just believe the facts that are told to you. Probe the client, probe the person who's appointed you, ask them questions to ensure that you have the full facts before you. Because if you're attacked on the stand because of inaccurate facts, that can be quite embarrassing. Another area of dispute that often arises is subjectivity. It's a matter of professional judgment. And a very common area is valuation methods. Shareholders disputes, sale of a business, acquisition of a business. You have valuation methods, loss of profit calculations. So you have various methods. For example, you have the income method, discounted cash flow method, cost method, market value. All of these are methods that are used very often. And you find in arbitrations, you have one expert using one method, the other expert using the other method. And why is that? Because that method gets the highest value for the parties who appointed him, right? So, so this leads to disputes, and this leads to questions about the expert's impartiality. And the last point, which is my last point, is actually related to the first one, is the party's instructions, right? Don't just believe the instructions, question the instructions, especially when you're reviewing the facts, when you're reviewing the documents. And as you become more familiar with the case, as an expert who is supposed to be objective, you should do that probing, you should ask the correct questions. So that's basically my very short presentation on what the role of an expert is. And I can open it for discussion.
Thank you, Kiran. While we're on this subject, perhaps could you let us know a little bit about what are some of the common mistakes and pitfalls that lawyers and the QS may face in a construction dispute?
Okay, one area that they may face is, I mean, I've also got slides on this, I think. If you want to share that, I've got some slides on this. Are you asking me the question?
Yeah, sure.
Yeah, could we share some slides on this as well? I think that's what was part of the, so maybe we might as well go into it. Now, let me just step away from the slides, okay? And I just want to add on to what Chulip mentioned earlier, and Vincent as well. I think the biggest pitfall from my experience in any construction dispute is the figures, right? It's quantities, it's basically the cost, how that is calculated. Now, a QS is supposed to be a construction cost consultant. He's supposed to monitor the cost of construction. He's supposed to be very familiar with costs. From my experience, I have seen in several adjudications, and in fact, one recent one where I did, is where no thought was, I mean, with all due respect to the QSs in our midst today, I mean, adjudications are very fast-paced. But one area where you often get attacked, and one common pitfall, also for lawyers to watch out for, is how did the QS arrive at that figure, right? For example, if a contractor is claiming 95 up to 95%, and you certify 90%, right? Why are you not certifying the balance 5%? Can you explain that? Or are you using a very broad brush approach? Have you applied that 5% to every single item in the contractor's claim, right? So that's where I've seen QSs and lawyers as well, lawyers who are fighting that case. I've seen QSs and lawyers alike encountering that problem, encountering that pitfall, where they are questioned on, right, okay, this cost that you're withholding, this amount that you're withholding, or this amount that you're paying, how did you calculate it? And at times I've seen both QSs and lawyers at a loss explaining it. Right? If I could have the next slide. So the duties of a QS is, just to follow up from that, apply your mind in evaluating the claims. Don't listen to the client. Okay, of course you've got to listen to the client's paid, but don't be led by the opinions of the client. You are supposed to be objective when you make that valuation. And if you're not objective when you make that valuation, when it comes to an arbitration, that is easily open to attack. And mind it, you're not bound by someone else's calculation. You're not bound by the engineer's calculations or engineer's methods. I mean, I've put a few cases there for your reference. You're not bound, even, I know the architect is often the head honcho in most projects. You're not bound by the opinion of the architect as well. As a QS, you need to make your own decision as far as the costs are concerned, as far as evaluating claims are concerned. And I repeat that again, that's what I see often, QSs and consultants falling into that trap where they are questioned about how they evaluated the claim. And sometimes they're at a loss in terms of explaining it. Now, not to alarm anyone out there, but there there have been cases out there where QSs have been, there have been QSs who've been sued for negligence, and we'll look at one or two of those cases soon. So the QS has the appropriate, I mean, QSs are very important in construction projects. They have that expertise to evaluate the quantities. They have the expertise to value the costs, and we should use them, and we should use them correctly. Could I have the next slide, please? So common pitfalls, I've explained this already, quantum issues. Make sure you are very familiar with the quantum issues. Make sure you know the maths inside out, right? The rates, the quantities that they've used to calculate, make sure you know them inside out. I mean, Chulip mentioned the BCA rates. Make sure you're aware of that, okay? Because calculations are often open to challenge if they are not calculated objectively. And if you don't calculate them objectively and you don't confront the client before it goes for arbitration or adjudication, then the last bullet point, that can prejudice the client's claim. It can lead to even greater losses or damages for the client. If I could have the next slide. Now, just two cases I just wanted to highlight, and these are UK cases. The first one is the case of Bank of Ireland and Watts Group. And this concerned the preparation of an initial appraisal report. Here in this case, the bank sued the QS after the developer to whom the bank had extended a loan went into liquidation in the middle of the construction of an apartment block, right? So bank actually appointed the QS, and the QS was retained by the bank to do cost calculations, costings that were submitted by the developer, the QS was supposed to assess, and that was needed in order for the bank to approve drawdowns as the work progressed. Now, the bank claimed that the initial appraisal report had not been prepared properly by the QS, and if it had, the bank said the loan would not have been approved. So here, thankfully, the QS was found not to be negligent because he was not in receipt of certain drawings which would have changed his appraisal report. But in any case, the court found that the bank would have funded the construction anyway. And in legal terms, the court found that there was no causation. The last case I want to share before I end my short presentation is the case of Russell and Stone. Again, a QS was sued in this case. Now here the employers engaged the QS for the construction of their home. And in Singapore, this is very common. You see it all over the place. You see people buying old homes, tearing them down, doing A&A works. So this is something similar that happened in the UK. Employers engaged the QS for the reconstruction of their home, and they sued the QS because they felt the QS was negligent and caused them to spend more on the construction and that they should have than they should have by failing to properly manage and advise on the tender process. So Chulip also mentioned this in his presentation, that another thing that QSs do is they advise on the tender process and they advise on the contract documents. Now, I'm not here to cause any misunderstanding between lawyers and QSs, right? But from my experience, and I have quite a number, and Ming, you have quite a number yourself, sometimes I feel that, you know, the QSs sometimes need to advise the client when it comes to tender processes, when it comes to the contract documents. There are certain areas. I know QSs are very familiar with the clauses. I know QSs are very familiar with the project, etc., etc. But with respect, at the end of the day, you're not lawyers, okay? Like I said, I'm not going to cause any misunderstanding here, but there are times where you need to maybe advise the client that this is something that a lawyer may need to advise you on, all right? So here the QS was sued because they didn't manage the tender process properly. They didn't manage the costing properly. But thankfully, again, the court found for the QS, and the court found that even if the QS had warned the employer about the risk of cost overrun, they would not have listened anyway. So that's very short presentation on the common pitfalls a QS may face. And just to sum up, in terms of calculations, be very familiar, assess the claims objectively, do not apply a broad brush approach. And of course, there may be times you need to be very familiar with the tender documents and with the contractual documents. Yeah, that's all me.
Oh, thank you very much, Kieran, for that. There is one question from the audience, and if I may just read it to you. And this is more like a general question on experts in general. And the question is, are experts regulated, and do they have a minimum education level? This is a question from Andrew Reeves.
Right. Are experts regulated, and do they have a minimum education level? From the best of my knowledge, as far as the tribunals and the courts are concerned, they are not regulated. But you may have your own professional bodies that have some degree of regulation. All right. So depending on the case, a case may require certain certified experts, for example, you know. So if I understand that correctly, are experts regulated? Not per se, not as far as appearing in court or tribunal is concerned, but your individual bodies may have some degree of regulation. What was the second part of the question, Min?
Do they have a minimum education level?
I think experts need to be very highly educated, considering the areas that they deal with. Just to answer the question directly, I don't think there's a minimum education level. I don't think there's a minimum education level. You just need to be competent in the area that you're giving advice in. I have seen experts who just have a basic degree. Okay, you may not have a PhD, you may not have a doctorate or even a master's, but I've seen experts who've done a great job who've just had a basic degree. I've also seen experts who've had no degrees. All right, for example, someone who's an expert in plumbing, for example, a case I dealt with many years ago, someone who was an expert in plumbing, and he had no degree. He was just a very experienced plumber. And the same thing, I had a dispute many years ago which dealt with generator sets. And the person that we put up as an expert didn't have a degree as well, but he had been dealing with generator sets and technical issues pertaining to the same for many years. So no minimal qualification.
Yes.
Depends on the case, yeah.
Thank you so much for that. There is one question that I think perhaps, David, you could just pick up on. Kieran mentioned this in the course of his talk. He would made it quite clear that the QSs need to make their decisions impartially, even though they're being paid by the party who has engaged them. So with party-appointed experts, we have this potentially artificial situation, David, where the expert is being paid by the party by whom he's been engaged, and yet he's supposed to be impartial. Nowadays, there's a little bit of a movement towards tribunal or court-appointed experts. Do you have any views on that?
Yes, this argument about whether party-appointed experts are paid employees or hired guns has been running around the industry for a long time.
Mm.
But on the whole, I think from my experience, a good party-appointed expert will act objectively and impartially. And if he's really doing his job properly, he'll disagree with his clients in some areas because that's his professional judgment. If he adopts everything the client says and tries to defend everything the client says, and often it's indefensible, he will not be credible as an expert witness. So I don't think there's a real issue. I mean, look at consultants on construction contracts. They're paid by the employer, but the law in many cases requires them to exercise an independent judgment. Same thing. So as far as tribunal experts are concerned, this is a hot topic again, but I think it's fair to say that parties in particular have a fundamental right to appoint their own experts, and they dislike intensely if that's taken away from them. The tribunal appoints an expert, and also they feel they have no control, particularly the lawyers feel they have no control what that expert's going to say or do, not that they should control, but they're just totally in the dark. And I think it's not a very popular matter, a tribunal expert. It hasn't got, in my experience, a lot of traction.
Yes.
In England, Rupert Jackson tried to introduce this when he did the civil justice costs, but it wasn't taken up. I think it's too unpopular. A bit like party-appointed arbitrators, parties have the fundamental right to appoint their own experts, provided they're professional and objective. That's fine, there should be no issue.
Absolutely. I guess it's a little bit like tennis, right? I mean, we call our own lines, and usually if the other player is out or in, we call it. And nobody really tries to game the system by making dubious calls. Otherwise, you won't have any friends left to play tennis with. Thank you so much. David, I know that you've sat as an arbitrator on over 150 arbitrations. So maybe from your perspective as the arbitrator, could you tell us a little bit about what the expectations of the arbitrator are as the decision maker of a QS, the expectations?
I'll be happy to. I mean, at the end of the day, you've worked hard as QSs during the contract, preparing the claims or defending the claims, and you've assisted in the arbitration, but you need to persuade the decision maker, people like myself, in the arbitration that the sums of money are due. So what am I looking for fundamentally? Firstly is cause and effect. You need to show that from the employer risk event, the matters which you're claiming loss and damage, they can be attributed to those delaying events. And if you just do a global claim, I think you're going to have difficulty before an arbitral tribunal. You've got to show a link in causation. And if you're claiming a loss which is too remote, that again under law will be dismissed. So you need to do the causal link, very important. Global claims sometimes can't be avoided if it's impossible to disentangle the various events and attribute loss and expense, but you can't generally get away with a global claim without some kickback from the tribunal. Certainly if you fail to keep adequate records, you can't put a global claim in legitimately, only in limited circumstances. Now, the question is often asked, what happens before a tribunal if there are concurrent causative events? And this happens quite often on a complicated project. There are various theories to deal with this, which tribunals will adopt one way or the other. The first is, as a QS or an expert, you need to find the dominant cause. The second is that it cancels each other out. There's a Mexican standoff. So if there's two concurrent delays, one by the employer, one by the contractor, the employer doesn't get to claim liquidated damages and the contractor doesn't get to claim loss and expense. And there's a famous UK case called Malmaison on that. As an expert, you need to, quantum expert and a QS, you need to substantiate your claim. It's all very well to put figures, but you need to show there's a train of documents to back up that claim. This, however, does not mean you need to do a complete audit and verify every single figure. Often sampling of records will be sufficient. If an expert comes before a tribunal and he adopts a strict audit approach, again, I think that will be unpopular. As I've mentioned, we as tribunal members like to see an objective, impartial expert, one who disagrees in certain instances with his own client. We can quickly work out if somebody is a hired gun who's advocating his own client's case. And I just want to read to you a couple of examples in the courts in England where it's gone horribly wrong, perhaps ended the experts' careers. And the first was a case called Colour Homes, where the judge said, "I've read Mr. X's report on the basis it was a partisan tract with no objectivity. He ignored virtually everything which was against his client. I give it no weight whatsoever." Well, that was not very equivocal, was it? And also the case of Mukin Bank v. Kensington, where Mr. X lost sight of the proper role of an expert in assisting the court. He adopted the role of an advocate. The value of his evidence is greatly diminished. So you have to be careful as an expert. The other thing I look for, and other tribunals look for, is cooperation between the experts on quantum to narrow the differences, usually in a joint report. And this is extremely important. I'm going to come on to that later in my second topic, but we as tribunals are very much happy to see cooperation and reduction in areas of dispute on quantum, agreement on figures as figures, etc. Just a quick word on adjudication, because I know this is a matter you all deal with. When you do an adjudication, you don't want to overload the adjudicated with too many documents, often of limited relevance, because there's a very limited time frame for adjudication. You need to put in succinct and quality written submissions, because you need to impress the adjudicator very quickly. And as a respondent, you need to set out all the reasons for withholding payment in some detail. Now, often the claim has been preparing for some time and catches the respondent by surprise by commencing adjudication, but the respondent must do his best in the limited time to present the areas for withholding payment. So those are the kind of areas I'd be looking for as a decision maker.
Mm-hmm. Thank you. That's certainly food for thought. While we're on that, there is a question from the audience, and it's more not so much about the expectations of the decision maker, but I think the standard by which the adjudicator or the arbitrator would judge matters. So if I'll just read the question is, what is the arbitrator's view on star rates based on the published costs? And I think here he's referring to the published costs of BCA guidelines that Tulip referred to as the source. So what is the arbitrator's view on the star rate based on the published cost as the source, as compared with similar star rates obtained from other projects with the same item, or quotations obtained from, for example, 3 different contractors, or any other sources that may be possible? Yeah. What's your view on that?
When you have star rates claimed in an arbitration, there's such a huge divergence between the star rates claimed, and you need to. And as an arbitrator, you're assisted by the party's experts or quantity surveyors, but you need to make the best evaluation and what is fair and reasonable. And from my personal point of view, I treat with some caution other contracts, because facts are different, the circumstances are different. I much prefer the published, because they're universally recognized indices in both Hong Kong and Singapore, and I personally give much more credence to that, subject to tweaking if necessary. But if you just say, well, this is what I claimed on another project, or this is what the other contractor, I'm a little bit wary, to be honest. But I think on this one, it may be open it up to Kirandeep or Tulip, whether they have any views on this.
Yeah, as I mentioned earlier about using the published rate, which I think there is a good basis. But again, as I mentioned earlier, you have to adjust the rate to the type of work you're doing, because the published rate in BCA's rate example, it comes from a fairly standard tender book system of big quantity rather than small area of adjustment just for variation. So some adjustment has to be made to it, and that adjustment should be spelled out nicely and show the arbitrator or the court that that's how you value out the rate. Whichever you can adjust, you shouldn't be going too far off, knowing that what other components that you need to add in. Example, you order a concrete in small quantity, you have to pay a surcharge for it, which no matter you order 1 meter cube or 9 meter cube, the same driver will deliver. So you have to pay that extra surcharge, as compared to in the standard published rate, they will not have such extra cost in it.
Mm-hmm.
Yes, that's good. Thank you.
Thank you. David, perhaps you could just to pick off from where we last left off, how can lawyers and expert witnesses make quantum issues as easy as possible for the decision maker?
Settle the case? No, only kidding. How do they make it easy? Well, I like to see well-structured, coherent and digestible financial claims and experts reports. If there are very detailed calculations and documents, they should be in appendices, so you don't lose track when reading the main report. I don't like exaggerated claims or ones where there's double counting or duplications. And often when you're claiming variations and loss and expense, there can be duplications in claiming overheads, for example. As I said earlier, you need to demonstrate cause and effect and avoid global claims. Appoint a very good expert who's reputable and is good in the witness box. And going on to what I particularly makes my life easy is a joint report which agrees quantum figures subject to proving liability. You can have figures as figures, and particularly useful is a daily rate of prolongation. That saves me a lot of trouble when eventually I decide the extension of time and the prolongation. And also the interest rate, and when that accrues is a useful thing to agree between the experts. If I get two experts that are unable to agree anything on figures as figures or quantum, then I don't have a particularly high regard for them. I may disregard the evidence and do the figures myself. The other thing is, if you get matters of dispute that can't be settled in the joint report, I will consider experts hot tubbing, which is not a Scandinavian naughty bath. It's actually people sequentially getting together as the experts and being asked questions by the tribunal and then questioned by counsel. And this can be effective provided the tribunal understands the issues and is on top of them, and provided the experts are not worried about. A boffin, for example, may not be very good in hot tubbing, whereas obviously a good advocate would be who's an expert. As I mentioned, make concessions as an expert. I like to see some concession to show the independence. Don't defend the indefensible. And just if I can mention a few specific things in relation to construction claims. On prolongation claims, which are common in, obviously in the industry, you need to show, if you can, the actual loss caused, the labor, materials, equipment, and prove that as much as possible. But when it comes to overheads, such as head office overheads, you're not able to, because those are attributable across a number of projects by the contractor. A formula such as Hudson or Emden is okay to do that. Profit's more difficult. You need to show that you could have earned profit had there been no prolongation, which is a more difficult lost opportunity. Disruption is a very difficult claim to succeed in arbitrations, in my experience. You need to show lack of productivity, for example, or loss and expense which would not have been incurred but for the events complained of. And prolongation is easy, but disruption is difficult. And in all of these, look at the Society of Construction Law protocol on delay and disruption, which provides very good guidance on how to claim. Variations is, again, I regard as a fairly easy one to assess, if not sometimes a little bit tedious, because you may have 100 or 1,000 variations. But if you can agree on the direct cost of labor, plant and materials as experts, that would save me a lot of trouble. And time-related costs associated are more difficult to be agreed. And also bear in mind, as QSs or experts, that as a matter of law, that you're bound to mitigate any losses you've suffered due to employer events. And there needs to be some measurement of mitigation, resequencing, but I'm not advocating you have to spend a lot of money in mitigating because you're not required by law to do that. You need to make some effort in rescheduling. Also, appointing the right expert is extremely important, someone who's good at what they do under cross-examination, independent, and can withstand withering cross-examination. And there's a salutary lesson I would end up with from a case in England called Van Ord, which you may be familiar with. And I'll just read what Mr. Justice Coulson said about the expert bolting the room during his cross-examination. I have endeavoured to give Mr. X the benefit of doubt. However, his abrupt departure from the witness box to go for a short break and then run for the nearest taxi never to return is a matter which I view with the utmost seriousness. He was not able to withstand the cross-examination because of his lack of experience. So appointed expert who's not a runner. Is what my last suggestion. Thank you.
Okay, thank you very much for that. I think we'll all certainly pay attention to that lesson. There are two questions from the audience from you, and if you could just answer them briefly, given the time that we have. The first question, David, is from Andrew Reeves. Do you have any views in particular on acceleration claims?
Accelerations claims have come up a lot in cases over the years, both as a partner of a previous law firm and also as an arbitrator. Again, I would put acceleration claims into the category of difficult along with disruption to prove, but sometimes they have been proved. If the contract may provide for expedition or acceleration in payment, let's assume it doesn't. If it can be demonstrated, for example, this is just an example, that the contractor made a number of claims for extensions of time and loss and expense, which were ignored. And then the employer said to him, you're behind. The architect then said, or engineer, you must expedite your works without referencing any clause in the contract. The contractor, when faced with a potential heavy liquidated damages clause, may have no choice but to spend money to accelerate. In which case, in certain circumstances, subject to certain proof of facts, he may well succeed. And I've seen him succeed in acceleration claims, but on the whole, it's a difficult claim to prove. I wonder whether anyone else has any experience of acceleration claims.
Yes, Kieran, would you have anything to add to that?
Yes, I was about to say, yeah, I think acceleration claims, I would agree with David, that they are difficult. The best, I mean, it would be easier if there was actually an order by the employer to accelerate. I'm dealing with a situation now where we have pleaded that there was an order by the employer, and we have used various minutes of meetings to show that there was an order by the employer. I think when it comes to the area of constructive acceleration, right? Now that's very difficult, and it's a concept that is, I think David would agree, not very well recognized, maybe recognized in the US, I think not so much in the Commonwealth. So if you're trying to show constructive acceleration in the sense that you're trying to show that acceleration was needed because of the circumstances, you know, because of what the employer did, I had to speed up to avoid legal damages, I mean, liquidated damages, and there was some degree of prevention on the part of the employer. I think that becomes quite difficult because that becomes very, in a way, it depends a lot on the facts. But if you have an order to accelerate, or an implied order to accelerate, that would make things easier. Yeah, I had a question for David. I mean, David, who was the QC that cross-examined that expert that ran away?
He's
we need to learn a thing or two from him.
He's not from my chambers, but I'm happy to give it to you privately.
All right. Okay.
Well, bring that to you. Let us know.
If I could just add to what David said about impartiality, and I think it's important for the experts to be impartial, not only because they've got to face the tribunal or they've got to face opposing counsel, but when you are impartial, you're actually doing your client a favor. If you come into the project and you are impartial and you're assessing everything impartially, you will point out weaknesses to your client, you know, and you can do, and then two things can flow from that. Either the client will agree to maybe settle that claim, or you're preparing the client in how to tackle that claim. You know, you point out weaknesses and you help the lawyer in that sense. So impartiality, I think it's not only because of your duty, but even as a paid expert, as an appointed expert, when you are impartial, you will be doing a service to your client.
So there are actually practical effects as well and practical results of being impartial.
That's right. That's right.
Yeah. Thank you so much, Kieran, for that. David, there's just one more question from the audience, and I'm just going to read the question, and it's on prolongation costs. The question from Daniel Chan is, how would loss and expense be looked at between the main contractor and the subcontractor, knowing that most subcontracts are quite loose?
Assuming there's not back-to-back arrangements, then Are we talking about assessing the contractor's claim and the subcontractor's claim, or a main contractor assessing the subcontractor? Not quite clear from the question.
I've read the question verbatim, but I would think that the question refers to claims by a subcon against the main con for loss and expense.
Yes, I mean, let's be frank, the subcontracts are not as standard form in many countries as they are, as main contracts are, and often they're loose, but nonetheless, as a decision maker, if the subcontractor proves enough cause and effect, proves that certain costs have been incurred, proves that he was not responsible for that event or the delay, and particularly if there are awards of extension of time under the main contract which impinge on that subcontractor's claim, which is clearly the employer's accepted that as a cause of delay, generically perhaps, then I would have some sympathy, even if the contract was a bit loose. There has to be certain burden of proof to be satisfied, but we're not talking about a strict approach. We're talking about abundance of evidence or balance of probabilities. So it shouldn't be an issue, provided that certain key matters that I mentioned earlier are satisfied despite the loose drafting.
Yes, yes. Thank you, David. Thank you. Thank you for those insights, very illuminating from the perspective of an arbitrator. This brings us to Vincent. Vincent, perhaps from the perspective of a QS, could you talk about how the expert witness can help the lawyers debunk the other side's quantum calculations and assessments?
Yep. Under the perspective of a quantum expert witness, we are able to help the lawyers to debug. But the main thing that we need to keep in mind is that we need to remain impartial to both instructing clients and lawyers. Sometimes both experts will have a different information before them, or interpreted the same information differently. Based on my experience, some tribunal wanted an expert report, joint report, and reply report. But some, they just want joint report first. So there's no always only one answer, I can say that. Therefore, expert usually on both sides. So we can start from the beginning of the appointments of the experts. Once we receive the documents, expert witness can help counsels in identifying any gaps and potential difficulties. Information sometimes is insufficient, such as drawings, detailed breakdowns of claim. For example, some statement of claims only disclose payments and tax invoices. Basically, this kind of information is insufficient for the respondent to have a full picture of a detailed claim. The next one is on the technical portion. Expert witness able to guide the counsel through the technical issue of the case. Some counsels might not specialize in the construction dispute. Expert witness able to help counsel to translate highly technical language into usable language. Some joint meeting between the claimants and the respondent could be assisting the tribunal to minimize the agreements. During the cross-examination preparations, expert able to help counsels on some key technical details and focus on the errors or omissions of the opponent expert report. Technical errors and inconsistency will be highlighted to help the counsel to understand the differences between the report lines. Lastly, during the closing submissions, some assistants analyzing the opposing expert evidence and preparations of the conclude chart and synopsis. So I will move a bit on the quantum side. Basically, there is two common areas, the dispute arising out of quantum calculations and assessment. First, we will go to the quantities. As a traditional QS, normally we will look at the quantities and rates. Quantity takeoff is one of the important elements of the construction dispute. dispute arising out of different methods of taking off. Some people, they will take off on site measurements, on plan measurements, some even using digital measurements. Some OQSs, they will go for manual measurements. So different methods of measurements from different QSs end up to have a different quantities outcome. The next thing is on the differences sets of the drawings. For example, there is a comparison between the approved drawings or the dispute drawing, which one should take precedence. The next one will be the fair and reasonable market rate. So there is as Tulip had mentioned and Kevin had mentioned about the fair and reasonable market rates. Sometimes it will based on the BCA, Barbados rate, or comparison of three quotations. So is comparison of three quotation is enough to justify as a fair and reasonable rate? So this one will be left to the tribunal to decide. So that's why it's very important to advise the clients to engage QS as a quantum expert. Yeah, that's all from my side.
Thank you very much. Tulip, would you have anything to add to that?
Yeah, generally I agree what Vincent has said. I'll say that in particular, the formula, especially the calculation and formulas of opposing expert, when it's shown, it's easier for us to debunk it, to pick up the area, being able to understand the complexity in the quantity surveying area. So it's easier for us to pick it up and debunk it.
Yes.
Yes.
Thank you. I'm just going to go to some of the questions from the audience. And this is from, I think, a quantity surveyor, Ho Kong Mo. So either Tulip or Vincent, you may want to answer this. And I'll just read it verbatim. If a contractor insists on the selection of a subcontractor, which the architect does not give consent to, how could the QS convince the arbitrator on the quantum of cost adjustment under a progress payment claim?
Could you repeat the question?
Yes.
Didn't get it
So
very well.
if the contractor insists on the selection of a subcontractor, which the architect does not give consent to, how could the QS convince the arbitrator on the quantum of cost adjustment under a progress payment claim? It's quite an interesting question.
Well, if the architect disagree with the employment of that subcontractor, then how would that subcontractor be employed? Engaged into that contract, I will know.
Yeah.
If he's not involved, if he's not been approved, he shouldn't be employed and shouldn't be any certification or of his work done.
I
can't see the link, sorry.
I think there is a few differences between there is some domestic subcontractors and named subcontractor, we can as per se. Because I think if it's a domestic subcontractor, I think the main contractors have the right to employ their own subcontractors. But for certain scope of work, let's say is some sort of a nomination from the employer, certain scope of work need to be done by certain contractors, then will be called, they will call it named subcontractors. So I'm not so sure, is he referring to domestic subcontractors or named subcontractors? Yeah.
Absolutely. There is another question, and this is from Ten Chun Huat. If you are a third expert and you are having to deal with two other experts' diverging opinions, what advice would you give to the third expert? Perhaps, David, you may just want to take this up.
Find another assignment. No, only kidding. I don't know the context of this because ordinarily the parties would appoint one expert each. Unless the tribunal appointed an expert, I don't know why the party would be appointing two experts, particularly as one of those experts disagreed with his own party expert. But I'm struggling to find the right answer to this because I don't understand why you'd have three experts on the same.
David, I think they're referring to maybe a tribunal-appointed expert, and if he has to deal with divergent views from party experts, how does he deal with that? I think maybe that's what the question is about. All
right. Well, in which case, he's got to do as any expert does, give his best analytical, objective opinion. If he probably, because he's appointed by the tribunal, will be given slightly more weight, I might hasten to add, provided he's got justifiable reasons for departing from the party-appointed expert's opinions, that might be given more weight. So it's quite unusual, though, for there to be two party-appointed experts and a tribunal expert.
Yes, it is quite an unusual situation, I guess. But I guess we're all just sort of thinking out of the box. This is just a question to any of the panel members, given the situation that we are in now, which is the COVID-19 situation leading us to this lovely webinar. What are your thoughts on the COVID-19 situation and how this impacts arbitration proceedings? I mean, yeah, the cost, and time of arbitration is not new, but with the pressing financial concerns and COVID, I think a lot of contractors are looking to how to cut costs, and they're looking at more effective ways of resolving the disputes, especially the lower value disputes. Would you have any thoughts on how to achieve this? Kieran, perhaps?
I think you've got the COVID-19 Temporary Measures Act. Yes. I think that is I'm not an assessor, but in our firm, we've given some of our junior lawyers the opportunity to be an assessor. And I hear quite positive things. I hear that they have managed to settle quite a number of claims. And that process seems to be working. So, the COVID-19 Temporary Measures Act may be an avenue, a cheap way, a cost-effective way of settling disputes, rather than taking it to adjudication or rather than taking it to arbitration. Secondly, of course, I think it should be an excuse. I wouldn't say an excuse, but try and settle your disputes, try and speak to one another, rather than take it up for arbitration or adjudication. Especially in terms of arbitration, I don't know what David may think as an arbitrator, but I tend to think that arbitration proceedings are being delayed these days because there's some parties who are not very willing to do virtual arbitrations. So if you were to take your disputes on the arbitration track in this climate, you may actually end up maybe spending more money because of the delays caused by COVID-19, because some parties are trying to delay arbitrations, push them back because they're not very they're not very enthusiastic about a virtual hearing.
Yes.
Have I answered your question, Ming? Is that right?
Yes.
I would just like to say that it's been remarkable how virtual hearings have become the new norm and how they proceeded across many jurisdictions successfully with the right platform, and how they've saved an enormous amount of costs, of travel costs and other things. But however, as Kieran mentioned, for a number of hearings, parties have postponed them for up to a year because they want an in-person hearing. And that has consequences for costs and also interesting questions as to the winning party's right to claim interest during that year. So there's interesting issues arising. But I think there's been a lot more settlement in this time of cases in times of this economic dislocation across the world. But coincidentally, there just seems to be an upsurge in arbitration. So perhaps people are sitting at home with nothing better to do than dream up starting a dispute and getting their normal job. But I'm all in favour of it.
I mean, it could be a case of, because these are unprecedented times, I think everyone is sort of digging their heels in and realizing that they need to enforce their rights now more than ever, perhaps. Yes. Would you have any other war stories to tell on that front, David?
Just an interesting question. If one party says, I want my hearing in September 2020, and the other party, ordinarily the respondent, says, I insist on an in-person meeting, in-person hearing, and I'm available in September 2021, what does the tribunal do? I think provided there's nothing in the rules or law of particular countries to stop a virtual hearing, I think the tribunal should proceed, because otherwise there's an inordinate delay. But it is a vexed question across jurisdictions, whether people are bold enough to have a virtual hearing, even though one party's objected to it. But I mean, I've seen many of those recently where the delay would be extraordinary and tribunals have just proceeded. And I think provided each side has been presented with a full opportunity to present their cases, which you are in a virtual hearing, I doubt if there'll be problems on enforcement, but remains to be seen.
Yes, I mean, I think it's quite an interesting area that we're facing. I mean, I myself, I've got an arbitration coming up in October, but I don't think it can be a real life arbitration anymore.
Just one war story. In the Vietnam International Arbitrations, the VIAC, you cannot proceed with a virtual hearing without the consent of both parties. And I've come across that in a case because that's just what the rules provide, but that is unusual.
David, do you think, I mean, as an arbitrator, is that at the back of your mind? If that happens, whether parties will try and set aside your award for breach of natural justice or some public policy reason, if you proceed with a virtual hearing when one party objects and wants an in-person hearing? I mean, is that something that would be at the back of your mind as an arbitrator?
It's always in the back of your mind, but if there's an inordinate delay before you have an in-person hearing, at the moment it's uncertain when you can have an in-person hearing. I still think, provided everything works during the virtual hearing and the witnesses are there, the experts are there, and there's no technical glitches, I still don't believe that there'll be a fundamental breach of due process which will enable a matter not to be enforced. But it depends on each country. You've got to look carefully at the institutional rules and also the rules of each country. In Vietnam, we'd be in trouble, as I mentioned.
In my experience of virtual hearings, Ming and David, is that I think one advantage is the document sharing is a lot faster. You know, rather than getting everybody to flip to the correct page, you know, the counsel just presents it on screen, everyone looks at it, you know, the relevant portion is highlighted and referred to, and you move on. So actually, there are a lot of you know, pros about a virtual hearing, even in terms of preparation. I mean, this is something that, you know, as an arbitrator, David, I mean, you maybe only see me, for example, but, you know, you can't see everyone. And I think there's a lot of, I wouldn't say scope for impropriety, but there's scope for, like, you know, signaling to someone to go and find a document, you know, some things you've forgotten, you know, where you pass a flag and you say, okay, please go get this document now. I need it. I've forgotten about it. You know, if you were in a big hearing where everyone could be seen, that would be a lot more obvious. I mean, that's just on the lighter side of things.
Yeah.
Of course, it's not the same as having it in person. I think we, as lawyers, you know, you like to see everyone. You like to see the expressions, and I for one, am waiting for it. I mean, I don't think virtual hearings are going to take off once this pandemic is gone, and I hope it's gone soon. I think we'll all be running back to court, and we'll all be running back to the Maxwell chambers or wherever we want to hold our arbitrations.
Yeah, definitely. I mean, for me, I'm a bit old school. I prefer the hard copy paper. I'm not into the screen sharing and clicking here and scrolling there, but I suppose that's a matter of preference. There are some questions coming in now from the audience, and this is, I think, something for either Tulip or Vincent to answer. From Sang Chin Alvin Ng, I'll just read the question verbatim. The star rates, there are 3 quotes to verify the actual market rate. There were issues where the three quotes should come from, the contractor or the consultant or the employer. So the 3 quotes were challenged. And basically, sorry, it's just jumped away from me. The 3 quotes were challenged, and currently we are working on basing 4 quotes, 3 from the contractor and another 1 or 2 from the QS. Do you have any specific guides or guidelines?
Maybe let me add something on this. I think basically there is certain requirement from the government agencies wanted to have some quotations obtained by the consultants. So that's why you end up 1 or 2 quotations need to come from the consultant itself. Because our majorities, last assessments of the VOs, majorities of the VOs quotations come from the contractor. So that's why the government agency step in, they're asking, where is the consultant code? So as a consultant, we need to do our independent check on the star rate itself. So basically, there is no right or wrong answer. I can say that it's just how you're going to interpret the fair and reasonable market rate, because everyone interpret it differently. Yeah.
And I suppose
literally, anything to add on?
Yeah, I think the source of the rate is very important, and how do you approach to get the market rate is very important. Because as I mentioned earlier, if you get it from any contractor, if they know that you're just getting the rate and they're not going to do the job, you won't get an accurate or good rate in it. You either get it very low to be sabotaged, or you get it very high on the other side, because they know that you won't be giving him the job. Why should he give you an accurate rate?
Yeah, absolutely. Since we're almost out of time, for each of the panelists, I'm just wondering, is there any main message that you would like the audience to take away? Or do you have any final piece of advice that you would like to give the audience before we end the session?
I mean, if I can just chip in on this star rates point, I mean, it's coming up all the time. And Vincent and Tulip, correct me if I'm barking up the wrong tree here, but you know, and I've seen it happen in some cases, wouldn't the easiest way to deal with this situation is to provide this in your contract document, in your specifications, somewhere that when it comes to star rates, how many quotations you must get, who you get the quotations from, and who obtains those quotations. I mean, I have seen it in some contracts where that issue has just been disposed of, where you point to a contractual clause. It may be in the particular conditions, it may be in specifications, it may be somewhere where the contractor is told when it comes to star rates, you need to get 3 quotations. And you know, so doesn't that dispose of all of these disputes? I mean, very often these disputes arise because it's not contractually provided for. The contractor may come with 1 quotation or 2 quotations. And somewhere or other, someone says, you know, where's your 3rd quotation? And the argument is, where does it provide that I must get 3 quotations? So I think one of the easiest ways, and I mean, as a lawyer, I mean, we're always looking at the contract too. I mean, my advice to QSs would be that I think work this into the contract so that you don't have unnecessary disputes over star rates, over who you get it from, over profit and attendance, etc., etc. So deal with it in the contract.
Yeah, I will agree with Kirim's comments over the star rate. I think some of the consultants, they did incorporate certain requirements of the star rates inside their contracts, but I think not everyone practicing the same thing. So some they incorporate inside the preliminaries or conditions of preliminaries. They put it. There's some regular meeting need to be organized with the QSs. Normally star rate, you need to come with the 3 quotations and etc. Yeah, I think there is some practice over that. Yeah. but just that not everyone they have a practice over the requirement in the contracts.
Thank you so much, Vincent. I'm getting like a little notification that our session is going to come to an end. I think that pretty much concludes our session today. I certainly enjoyed this panel discussion very much, and I hope everyone else did. And I hope the audience got some insights into the critical role that is played by the QS at arbitration. And everyone got some perspectives on quantum disputes and how to win them. That just leaves me to say a very, very big thank you to the organizers, to the SIAC, to the SISV, to Emin, to Denton's Rodike for hosting this session. Thank you so much. And a big thank you to each and every one of the panelists. Thank you so much for taking time out from your busy schedule today to share your views and your experience and your collective wisdom with all of us. It's been very enlightening. And of course, last but not least, a very big thank you to the audience for your participation and all your very interesting questions. Quite interesting to see all the different perspectives, and the topic was really quite interesting to me. Thank you so much, everyone.
Thank you.
Thank you, everyone. Thank you.
Thank you.
Thank you.